Either the mother or the daughter was responsible for damaging your property. Yes, Mom. That's false. I don't even know who that person is. The police compared your image to that. That's irrelevant. Have you lost your mind? Foe, go see a psychiatrist. And now the conclusion, Rishita Frazier has brought a case against her former clients, Jada Millette and Antoinette Shavers, alleging property damage and defamation online. Now we turn to your claim. Faye, the judge begins. Yes, Mom. At this point, neither side has anything. You don't have your photos and you've returned the money. Clearly, there were disagreements. Perhaps you felt the client was unreasonable, and perhaps they felt the same about you. So in that sense, things are even. Correct? Yes, Mom. What happened next? I refunded the $250. The mother replied in all caps, saying that wasn't smart. The daughter kept calling repeatedly. Eventually, I answered. She was yelling, demanding her photos, asking why I refunded the money. I told her she had her refund, that they were too difficult to work with, and I couldn't continue. I told her to find another photographer. She responded, all right, I got you. Give me 15 to 20 minutes. This was on the 29th. Yes, Mom. Then I received a call telling me to get home immediately, that someone was destroying my backyard. I submitted the video as evidence. When you say someone was damaging your property, you're suggesting it was either the mother or the daughter, correct? Yes, Mom. That's a major part of my case. The judge turns to the defense. In your response, you state that this accusation is false and that you have no idea what she's talking about. Is that correct? Yes. I'm going to review the video. I hope it's clear. And we'll also address your counterclaim afterward. The video begins. This has happened to her multiple times. It wasn't me, the defendant insists. She carries bear mace. I have a police report. Just a moment, the judge says. I need to see that. I don't know who that is. The defendant continues. I also have witness statements. I don't accept statements from others, the judge replies. Let me see the police report. The defendant points out physical differences. That's not me. I have tattoos, piercings. The judge interrupts. I can't clearly see those details in the image. However, the Bakersfield police compared this footage to your California ID and identified you. You do have a driver's license, correct? Yes. They matched your photo to the person in the video. The judge notes the timing. This occurred on the 29th, the same day you didn't receive your photographs. That's quite a coincidence. The defendant insists she was elsewhere. We were in Las Vegas. Do you have proof? Yes, then show it. The defendant searches but fails to produce anything. The judge continues. So far, I have no proof you were in Nevada. What I do have is a police comparison linking your daughter's ID to the individual in the video. The discussion shifts. After the vandalism, did you have any communication with her? No. That's not true, the plaintiff says. She threatened me. Show me, the judge demands. The defense claims their only communication was through Facebook, though calls and texts are alleged. A video is introduced in which heated words are exchanged, insults thrown, and threats implied. The judge grows impatient. Enough. Let's move on. She turns to the photo shoot. You chose to take provocative photos for your 21st birthday. Yes. And this image was posted online? Yes, that's me. Who posted it? My mother. It was part of a review. The judge explains firmly, people are allowed to post negative reviews about services. That is not illegal. She then asks about damages. The cost to repair the windows? $1. $378. The judge revisits the timeline. Police identified your daughter from the video. You claim you were in Las Vegas, yet you've provided no proof. Based on the evidence, I am relying on the police identification. She delivers her reasoning. In addition to returning their money and refusing service, the timing and identification point to responsibility for the damage. I'm awarding $400 for the windows, plus $600 for trespass and disruption. The defendant tries to interject, but the judge cuts her off. You both behaved poorly, the judge says sharply. The entire situation escalated unnecessarily. The conversation shifts again to the nature of the photos. The judge expresses disbelief at the decision to take such revealing images, emphasizing personal responsibility. If you don't want something made public, don't create it, she states bluntly. Now, the counterclaim. The defendant alleges that a nude photo of her was posted online. I want to see it, the judge says. After reviewing, the judge notes, I didn't see any nude images from your photo shoot. So if such a photo exists, 4. It must have come from somewhere else. The defendant explains it was taken during an altercation without her consent. A video is shown, revealing a chaotic scene where the image appears to have originated. So now we know where it came from, the judge concludes. Someone captured it during that incident. The question becomes whether reposting it was unlawful. If the image was already circulating and someone sent it to her, she is permitted to share it. The judge rules. The defendant objects, calling it revenge behavior, but the judge dismisses the argument. In that case, your counterclaim is dismissed. She delivers the final judgment. 4. A judgment for the plaintiff in the amount of $2,000. This case is concluded. The courtroom quiets outside. Both sides reflect. I completely disagree with the decision, the defendant says. Justice wasn't served. 4. The plaintiff responds, I'm satisfied. I didn't get everything I wanted, but I'm pleased. Each side recounts their version, one calling the experience unprofessional and damaging, the other describing the clients as impossible from the beginning. From the bench, the reasoning is clear. In a service business, one must strive to accommodate clients, but there are limits. In this case, those limits were reached, and the consequences followed.